Welcome to the show today. We have attorneys from the Gadsden law firm, Allenstein Allenstein, here with us today. Myron and Rosemary Allenstein, thank you for being here today. How are you?
Doing great. Thanks for having us here today.
Wonderful.
I feel good. It's a pleasure to be here. Thank you.
Thank you very much. How long have you two been practicing law?
I've been practicing law 35 years here in Gadsden. I was born and raised in Gadsden.
I've been practicing here 8 years.
8 years. And you are currently the only father and daughter team in Gadsden, is that correct?
One of the few.
One of the few?
Right.
Well, we're glad to have you. And we're here to talk today about Social Security claims and disability. Rosemary, let me start with you. Tell me about those Social Security claims. What do I need to know about them? What qualifies for Social Security benefits?
Basically, if you are unable to work full-time, that means 40 hours per week, then you may qualify for Social Security disability benefits. Now, there are two different programs. There's Social Security Disability. That's the program that you pay into when you get the deductions taken out of your check each week. Then there is SSI. SSI is more of a safety net type of program, and you have to make sure you don't have too many resources or assets to qualify for the SSI program.
I see. And how do you apply for those benefits?
You can apply online at www.ssa.gov, or you can go to your local Social Security office. They will have an application there that you fill out. It takes generally about 4 months, and then they will write you a letter to let you know whether your case has been approved or whether your claim has been denied.
And are those the only steps once you apply? Take me through the steps once you apply for those benefits.
If you receive that letter from the Social Security Administration where they are telling you that your claim has been denied, that is an excellent time to consult with an attorney to determine whether you should file an appeal. An attorney will tell you whether you have a good chance of winning your case on an appeal. Now, when you file an appeal, you are asking to present your case in front of a judge. Anytime we get any good evidence in on these cases, however, we write and explain to the judge why we think you should win your case without a hearing. So while the normal process takes about 9 to 12 months, we try to win everyone's case without actually going to that hearing.
So it's always beneficial to go, to be able to go without going in front of the judge. But what happens when you do go in front of the judge?
It's actually a very informal conference type of a hearing. It's not like a trial where you're on the stand and a jury's there, that sort of thing. We go in front of the judge and we explain what your conditions are. You get to explain to him yourself what your limitations are. And it's an excellent opportunity to really have him see you and know what you're struggling with. And
once he hears your case, how long does it take to get a decision?
It generally takes about 1 to 3 months. However, they do have a process set up where they can issue a decision as early as about 3 weeks after the hearing.
Okay. And how do you go about then proving the claim or proving your claim for your client?
Myron, do you want to address that?
Yeah. First of all, we get all the doctor's records, but we find a lot of people don't have good evidence of how disabled they actually are. For example, a lot of people have dropped out of school in the 7th or 8th grade, and therefore they have low IQ. And so oftentimes we'll send people out to get IQ testing. A lot of times perhaps a specialist needs to evaluate the patient, so sometimes we send them to a rheumatologist. And so sometimes we find that we have to help people develop the medical records in order to prove their case, and so we try to do that for them.
Wonderful. Are there any other benefits available if you are unable to work?
I'm glad you asked that. In addition to Social Security claims, we handle what's called ERISA claims. And ERISA refers to private insurance claims. A lot of people through employment have disability insurance, short-term disability, long-term disability, and oftentimes when a disabled person comes out of work and applies for disability, oftentimes they get that disability, but often we see that 6 months, even maybe 2 years later, they terminate the benefits. And once you get notice that they're terminating the benefits, it's so important to get an attorney to review the medical records, to supplement that file. And we're one of the few law firms here in Gadsden that handles ERISA cases. And ERISA, let me tell you what ERISA is.
Thank you.
ERISA is a federal law that preempts or supersedes all claims for insurance, employment insurance related claims. For example, people have medical insurance through employment and they have disability insurance. Anytime a person makes a claim on those kind of policies, ERISA, a federal law, applies, and what that does, that takes the case automatically into federal court, and you have a whole different law that you have to deal with. And so you really need an attorney that knows about ERISA and is familiar with going to federal court. And that's one of the areas that we have
Specialized in.
undertaken, yes.
Well, you provide a tremendous service. With people having claims such as you've just described, when should they come and talk to an attorney? When is it too late? Is it ever too early?
For Social Security claims, we like to see the client just as soon as you have received the denial letter. Now, on long-term disability claims,
Well, we like to encourage people to collect their benefits without having to pay an attorney's fee. And so we say go ahead and apply, but if you get turned down, that's when it's important to come see an attorney right away. Because once you get turned down, your rights are in jeopardy. And let me say this, we encourage people to see an attorney right away. If there's any question about whether to see an attorney, go see an attorney. Most attorneys will not charge anything for just sitting down and talking to you about the case. And then we always tell people, if you come against a brick wall and you see there's a problem, then you come back and we'll talk about signing a contract at that time.
So, Myron, you've described to us what ERISA is. Tell us more a little bit about the process.
Okay. When a client comes to me, the first thing we do is file an administrative appeal. Before we go into court, we have to file an administrative appeal and what we call exhaust our administrative remedies. So what we like to do, we like to get the claim file. And the insurance company has to give us the claim file. Once we get that claim file, we review it to see if there's sufficient evidence in the claim file to win the case. If not, we need to write the doctor a letter, and I just have to explain to the doctor, we need a statement from you that your patient is totally disabled. Will you please help us on this? And usually they'll help us on that. But those kind of letters are so important. So what we need to do, we need to build the claim file and put strong evidence in the claim file that the client is disabled. Now the insurance company still may deny the claim, but then we're ready to file the lawsuit. So we file the lawsuit in Etowah County. Because it's a federal law involved, the case is transferred to federal court. And then the next step after that is we file motions for summary judgment saying, Judge, based on the records, we're entitled to win this case. This claim should not have been denied. Hardly anyone ever goes to court on these cases. They're almost always submitted on the record, and the judge decides on the record whether the claim should have been denied or terminated. And that's why it's so important to get as much favorable evidence in the record before the lawsuit is filed. And that's what we do.
Well, let's shift gears a little bit and go back to Social Security benefits. Rosemary, let's say I am receiving benefits. Can I still work? Can I still work part-time?
That's an excellent question and one that I hear a lot. You are allowed to do part-time work while you are receiving disability benefits. Now, if you are receiving SSI benefits, your monthly benefit will be reduced if you are working. If you are receiving disability benefits, your monthly benefit will not be reduced. And you are allowed to work and earn up to $940 per month. If you begin earning over $940 per month, then the Social Security Administration will review your claim and likely determine that you are now capable of full-time work.
Again, I'm receiving Social Security benefits. What about my health insurance? Does that affect that at all?
When you receive disability benefits, you will also receive health insurance. Remember, we talked about the two different kinds of disability benefits now. If you receive the SSI benefits, you receive Medicaid immediately, and it goes back to the date that you became disabled and will pay your old medical bills if you will give that information to your medical providers. Now, on disability, you receive Medicare. Medicare takes 2 years and 5 months to kick in, so that can be troublesome when you don't have health insurance.
So, Myron, is there anything that we've left out regarding Social Security and benefits or ERISA?
Eric, I appreciate you asking that questions, and we are so appreciative of the opportunity to appear on the show because we hear so many questions for people, and we wanted to come and just help people understand their rights better, understand how the process, make it easier to understand, know when to hire an attorney, when not to hire an attorney. And let me say, a lot of this information is available on our website. We have a website at www.allenstein.com, and we can both be reached by email at rose@allenstein.com and myron@allenstein.com. And we get a lot of emails, and we'd be happy to respond to those. And we even have an ERISA primer on our website that just explains this ERISA, because people just don't understand ERISA. And so our purpose in being here is to help people understand what they're entitled to, when they need to hire an attorney, and just make it easier to understand and have rights more accessible. And so we just are so appreciative of the opportunity to be here and explain some of these things.
Well, we're all fortunate for having you here in Gadsden. Thank you both for being here today. That's Allenstein and Allenstein here in Gadsden, Alabama, for all of your Social Security or disability needs. Welcome to the show today. We have with us again Myron and Rosemary Allenstein of Allenstein and Allenstein. Thank you for being here again today.
Thanks for having us.
Yeah, thank you, Eric.
You also handle auto accidents and claims. Why does a person need to consult an attorney when they've been in an auto accident?
Well, the law provides that if a person drives negligently, and that just simply means carelessly, and they injure another person through that negligence, that person is responsible for all of those injuries that they caused. Now, hopefully that person purchased liability insurance, and there is an insurance policy available to cover those injuries. You need to speak with an attorney, though, to determine what your rights are, what you're entitled to under the law. And the first person who may call you is an insurance adjuster. But the insurance adjuster has a job to protect the income of his insurance company that he works for. And so an attorney then will represent an injured person and make sure that they receive the compensation that they are entitled to under the law.
Wonderful. And these settlements, who pays for the settlements regarding that?
If that person purchased liability insurance, the insurance company pays for the settlement.
And what's the maximum you can collect?
That's a great question, and it's different under different circumstances. When a person goes and buys insurance, they tell the agent how much they would like to purchase. The law in Alabama requires that you purchase a minimum amount of $20,000. It recently went up to $25,000. Still, most policies at this time are at the $20,000 level. So, if that is all the liability insurance that person purchased, then that is the maximum amount that you can collect from that insurance policy. Now, many people purchase policies larger than that, of course, to protect their assets, and so it's just different under different circumstances.
And you always hear the horror stories of those drivers who don't currently have insurance. What options do you have at that point?
That's also an excellent point. Even though the law requires insurance, there are many drivers still, of course, who drive without insurance. And unfortunately, accidents occur with drivers who either have no insurance or do not have enough insurance to cover the injuries that you received as a result of their carelessness. That's why it's so important to purchase uninsured motorist coverage. This is something that you purchase on your own policy. It's a relatively inexpensive coverage, but an extremely valuable coverage.
And how much of that coverage should you purchase as an individual?
The law requires that they allow you to purchase as much liability insurance as you have purchased on your policy. So we recommend that you purchase the maximum amount available.
Eric, I'd like to say this is a very good value for insurance, and we encourage people to have high limits, at least I would say 100, 300, if not even 300, 500, and then have your uninsured motorist at the same level. If you get in an accident with an uninsured motorist and you have to go to the hospital bills can just be astronomical, and you can run up a $100,000 bill pretty quickly. And so just for your own benefit, it's just important to have high uninsured, which is the same as underinsured motorist coverage, and it's relatively inexpensive insurance, and it's an excellent buy. Some people make the mistake of having high liability limits but low uninsured motorists, and that's just a mistake. We like to encourage people to have high uninsured limits.
I think that's when those horror stories start, or with the high medical bills, as you
Right.
just stated. So in that situation, when do you file suit, or when would you be able to file suit regarding a collision?
We try to work claims out before filing suit. We do everything we can to present the claim to the adjuster and to get a settlement that is fair and just for the client. However, sometimes that is just not possible, and that requires that we file a lawsuit. You must file the lawsuit within 2 years of the date of the accident. And unfortunately, it can become a slow and cumbersome process, but we are experienced in handling that, and we'll take care of that for the client.
You know, Eric, could I say, some people have the image of people that get in an accident and they just run in to file a quick lawsuit hoping to get rich, and that's just the furthest thing from the truth. Anytime anybody goes to an attorney, there's just a very slow process. We always try to get the case settled without filing a lawsuit. We have to substantiate all the medical records. We have diagnostic tests, and the last thing any attorney wants to do is what's called a frivolous lawsuit. We can't waste our time and our energy and our resources on frivolous lawsuits. The cases we take to court are people who have been injured and have just not been able to get a fair settlement. And let me say this, another thing people don't realize, when you go to court and you have a claim, oftentimes the jury doesn't realize that the person who's being sued has an insurance policy. And any judgment that the jury awards is really the insurance company is going to pay that judgment. But that's one thing that's kind of unusual. But in Alabama, we are not allowed to tell the juries that the person who is being sued has insurance, and the insurance company is going to pay the award. And oftentimes, if we get an award more than the policy limits, well, then the client, the person who was injured, their insurance is going to pay the difference. So most of these claims, I mean, by far the great majority, are all going to be paid by insurance and not by private people.
So other than the time involved in going to court, what are some of the problems that you face once that option is put into action?
Just what Myron mentioned, it is so hard for jurors to rule against a person when they feel like that person could lose their home or have their wages garnished to pay this judgment. It really ties our hands because we're just not allowed to mention that they have insurance. So that insurance is there, is available, and it will pay those judgments. We don't take people's homes from them or garnish their wages. We don't take cases like that because really it's hard to enforce judgments in Alabama.
Eric, let me add one thing. There's one key thing that is said in a jury trial to alert a jury that there is insurance in the case. When the judge is qualifying the juror, he'll ask, are there any policyholders of the insurance company? Are there any policyholders of State Farm or Progressive Insurance Company? And that's the only mention of insurance. But that question alerts the jurors that there is insurance in the case. But they're not told there's insurance in the case. They're just asked, are there any policyholders? But that is a sure statement that there is insurance in the case. And some jurors know that, and many jurors don't know that.
Another problem we come across is that we must prove all of these medical records and bills are related to the accident. And sometimes doctors are just not willing to say that for us for whatever reason. They're maybe timid about giving the deposition or just not sure what the standards are. But if those doctors will not say that those records are related to the accident, those records and bills just do not go in front of the jury. That's also very difficult for us.
And I understand that the doctors, they're there to treat the patients, and they're not there to give a legal analysis of causation, and they feel like sometimes that's just not their function. But
Issue of liability on their part.
Unfortunately, it is our responsibility. We have to prove it's all connected, and so sometimes it's difficult to prove that.
So, in all of this, when should an individual come see you?
For an automobile accident, if they have been injured in the accident, I recommend that they consult with an attorney immediately. A lot of times people just hope things are going to get better. 6 months later, they're in horrible condition and they haven't received the medical treatment that they need. So we like to be involved early on to make sure that they are receiving the treatment that is appropriate.
And is there any other thing than time? You said 2 years was basically the time that they had to file a claim, or from filing a suit, or that would destroy their claim in an automobile accident.
Well, if there's a question about who caused the accident, that makes it difficult. We investigate these things very thoroughly before we file suit. We wouldn't file suit if we didn't feel like we were certain about who caused the accident. A delay in treatment, like I said, can be very damaging to their case.
Let me say, too, an insurance company will search, especially on a substantial claim, they will search an individual's past medical records, trying to find that there was they fell down 3 years ago, or there was a small accident 5 years ago. And of course, the insurance company is anxious to prove that the injuries that we're claiming were not caused by the accident, but were caused somewhere else in life. And so they will review all the medical records and try to find any prior back problems, prior falls, prior accidents, and hoping to convince the jury that the problems that are being presented to the jury are not related to the accident. So that's a big issue at trial.
I'm sure it is. And other than medical records and proving that those injuries were indeed caused by the accident, what are some of the other things that some of the other information that you request from the individuals filing the claim?
Let me respond to that. Some of our clients are not perfect people. And some of them, they've had problems back when they were younger. Maybe they had a DUI, they're driving while intoxicated. Maybe there was a crime committed. Of course, anytime you have a case like that, that becomes important. It hurts the client's credibility. And all of a sudden, that becomes, it seemed like, almost more important than the accident itself. And so these are some of the problems we face. We represent people who are not perfect, and they've had some problems in their past. And so we have to convince the jury that the problems they're having now are related to the accident and have nothing to do with any prior problem that they may have had, perhaps even when they were a young man or a young woman.
Easier said than done.
Yeah, amen.
And what, other than serious injury, are there other circumstances that you can still file a claim regarding an accident?
Really, it depends on what the doctor has said about your condition. If you have a very minor injury, we will still talk to you and explain to you what your rights are, and it may be that you don't even need an attorney, and that happens frequently. But it's still important to talk with an attorney because you just don't know unless you go and find out if anything is wrong with you.
And again, so many people are afraid to go see an attorney because they're afraid they're going to get a big bill from the attorney. And attorneys that handle accident cases, I think all the attorneys are willing to talk to people without charging them anything, just advise them of their rights, and then a decision can be made whether to hire the attorney. But almost all the attorneys we know are willing to talk to people who have been involved in an accident just to discuss what the rights are and what should be done. And let me tell you another issue on trials that's important. There's a concept called contributory negligence. And if the person who's injured is responsible for the accident in any way, maybe they were speeding a little bit, maybe they failed to come to a complete stop, maybe they started and stopped suddenly, anything like that, the insurance company will always argue that, your client was partially at fault. And under Alabama, if you're partially at fault, you lose, basically. So if a jury concludes that both parties are somewhat at fault, all of a sudden we lose the case. And it almost seems like an unfair concept, but that is the law in Alabama. If our clients are at fault in any way for the accident and the jury agrees, you lose the case.
And Rosemary, to follow up on claims regarding automobile accidents, what are some of the other damages, not to say medical bills, that folks can expect to receive back?
That's an excellent question. Alabama law provides that when a person injures you and they were negligent and caused your injuries, you are entitled to recover your medical expenses, past and future, your lost wages, past and future, mental distress, pain and suffering, loss of the quality of life. So those are some of the other claims that we make for when a person is injured in an automobile accident.
Thank you very much. That's all the time that we have for today, but Myron, have we forgotten anything?
Eric, I'd just like to thank you for inviting us here, and we find in talking to hundreds of people that people are sometimes reluctant to go see an attorney. They don't understand the process, and we wanted to come just let people know what their rights are, try to make it easier to understand, and let them know that attorneys are very accessible. And we have a website I'd just like to mention. We're found at www.allenstein.com. We can both be emailed at myron@allenstein.com, rose@allenstein.com. We get emails, we respond to those emails. That doesn't mean you've hired us, we're just sharing information, and we like to let people know what their rights are, that it's easy to see an attorney, and if there's any question about what your rights are, you just need to go talk to an attorney and just find out, and that's why we're here. We really appreciate the opportunity of letting people know what their rights are and how easy it is to see an attorney.
Well, thank you both for being here and for the service you provide for Gadsden. That's Allenstein and Allenstein here in Gadsden, Alabama. www.allenstein.com.